Can you please explain the transaction in a joint development agreement and the related barter aspect?
So, what happens in a joint development agreement is that the landowners would transfer the land to the developer. The developer will do the construction on that land, and out of the constructed units, a part of that constructed unit will go to the landowner. So, in a way, the transaction, what happens is the landowner transfers the development right. That development right is nothing but transfer of land, which will happen at some point of time, and the developer would give the developed units or the built up units after some point of time. So let us understand what this barter is, and let's go back to hundreds of years back when this barter used to happen. Farmers or other people would exchange X for Y. So, for instance, exchange apple for rice. Apple may be grown at some point of time, rice may be grown at some other point of time, but the timing may not be important, and hence they would sit. The villagers who would want to do the barter would go to the sarpanch would then witness the transaction and say that apples could be given now but rice could be given at a later stage. Same is the transaction of barter in these joint development agreements. What happens is that the land has to be transferred, but land cannot be transferred now because there is risk. Land will be transferred at a later stage. The constructed property cannot be given now because the construction will happen at a later stage. So what gets transferred today at day one at the time of the signing of the joint development agreement is only the transfer of development right. But what is the moot point is whether this transfer of development right has any essence, or whether this transfer of development right means nothing in case the land is not transferred. And hence the moot point which arises is whether in these joint development agreements the essence of the transaction on one side of the barter is to transfer that land.
What is the GST controversy with respect to such agreements?
So the GST controversy is whether by way of a notification the transaction, which essentially is transfer of development right, but in any case concludes by way of a conveyance deed, by way of transfer of land, could be subject to the GST provisions. We must not forget that as far as the GST is concerned, there cannot be any GST on the transfer of land, supply of building, and things like that. And if that is the moot point and that is what the law provides, the question is by way of a notification which provides for the point of taxation to tax something, can the notification actually provide point of taxation to tax something which is excluded from the purview of GST under the GST regime?
Will the pronouncement of the judgment of Telangana High Court result in coercive recoveries?
When we argued before Telangana High Court, the question and the moot point was only with respect to the constitutionality of imposing this tax and also the constitutionality of this notification. While the Honorable Telangana High Court may have upheld the constitutional validity, that does not mean that there can be coercive recoveries. There has to be a process in law which is prescribed, which has to be followed. And also please remember that the valuation of the service will be of utmost importance here. The businesses, the real estate players must now at the same time get into the act of valuing this transfer of development right. Whether the constitutional validity is upheld at the Supreme Court or not, the valuation of this development right will be of essence and will have to be tested at different stages. For the adjudicating authorities to confirm the demand, they will have to follow the process of law by way of issuance of the show cause notice. The Telangana High Court, when we argued, we were very clear before the Telangana High Court that this petition is only with respect to testing the constitutional validity and has nothing to do with the valuation of the development right per se. And hence, the adjudicating authorities will have now the dual task of not only crossing the bridge of the statutory provisions but also the valuation aspect.
Roadmap for joint development transactions now.
I think the roadmap is very clear. This order would go to the Supreme Court, and I think a lot of petitions which are pending all throughout the country will move to the Supreme Court by way of interlocutory applications, by way of SLP, writs, etc. And I think the constitutional validity test will be concluded at the Supreme Court. As far as the developers are concerned, they must get into the activity of valuing the consideration for the service, have an arithmetic computation which is relevant and based on facts and circumstances.
Will it be fair to suggest that such transactions will become less lucrative now?
I knew that that question would come. See, of course, when there will be a high tax on a transaction which is of barter, and where there will be a lot of tax cascading because of the tax implications on this, and please do not forget that there are stamp duty implications already which are there on these transactions in some way or the other. These will certainly be less lucrative if the tax is imposed on the development right. And hence, I think both in spirit and in law, this must be relooked from the perspective of giving tax relief or the incentives to all stakeholders. It is not only for the real estate players, but also for the home buyers or for those people who would want to opt for redevelopment of their projects, because they would at the end of the day not get the desired incremental either in terms of the per square feet or in terms of the corpus or other monetary benefits. So I think yes, from the overall perspective, it may have an impact. We all will have to wait with a bated breath to see how this is concluded at the Supreme Court level. And I'm sure it will not be only the arbitrariness under Article 14 which will be tested, but also the substance over form.